Welcome to Gowling WLG's GoXL, an online tool to provide you with the information that you need to learn about and stay up to date on IP laws and procedures. My name is Scott Jolliffe. I'm here with my partner, Wendy Wagner. We're going to talk about the United States-Mexico-Canada Trade Agreement and the provisions in the agreement that deal with intellectual property rights, digital trade, and privacy laws in Canada. And just as a reminder, our discussion today is for information purposes only and should not be taken as providing legal advice. The USMCA is a trilateral trade agreement signed by the three countries on November 30, 2018, and then further revised on December 10, 2019. The Canadian government passed the Canada-United States-Mexico Implementation Act on March 13, 2020, to give effect to most of the changes required by Canada to comply with the USMCA. The agreement itself came into effect in all three countries on July 1, 2020, and is known as the CUSMA in Canada, the USMCA in the United States, and the TMEC in Mexico. We'll just refer to it here as the USMCA. This trade agreement provides the most comprehensive package of IP coverage of any international trade agreement since the trade-related aspects of Intellectual Property Agreement, or TRIPS, in 1994. Essentially, it brings Canada and Mexico in line with modern US law in many areas of IP. It also sets a new standard for the negotiation of future trade agreements by the US, Canada, and Mexico. Many of the IP obligations under the USMCA had already been adopted by Canada over the last few years. Mexico itself has recently adopted a new industrial property law to implement the changes required by Mexico to comply with the agreement. Interestingly, the USMCA is a living agreement, in the sense that it creates a new Intergovernmental Committee on IP Rights, or the IPRC, to consider several things, including new approaches to reducing IP infringement, strengthening the border enforcement of IP rights, exchanging information on the value of trade secrets, enhancing procedural fairness in the choice of venue in patent disputes, and mediating disputes over geographical indications. As regards patents, several of the USMCA provisions relating to patentable subject matter, transparency of the patent system, and data protection were already incorporated into Canada's patent laws. For example, the period of protection for confidential data submitted for marketing approval for pharmaceuticals and agricultural chemicals will remain at 8 years in Canada, not the 10-year period as originally agreed upon in November 2018. But Canada will be required within 4.5 years to implement a patent restoration term, allowing for the recovery of time lost in the prosecution of a patent due to unreasonable delays by the Patent Office. In the trademark area, many of the USMCA's obligations relating to trademarks have been part of Canada's trademark laws for many years, including the registrability of certification marks and the abolition of registered user requirements. Other obligations provided in the agreement are reflected in the amendments to the Trademarks Act that came into effect on June 17, 2019, including the adoption of the Madrid Protocol, the Singapore Treaty, and the Nice classification system. But to comply with the agreement, Canada will be required to provide protection for collective marks and make modifications to its protection for geographical indications. Canada will also be required to create new provisions for the imposition of statutory damages for trademark counterfeiting. In the copyright area, the USMCA requires a term of copyright protection for the life of the author plus 70 years, and no less than 75 years from the date of first authorized publication of a work created by an entity. Canada now has 2.5 years to adopt this extended term, whereas the current term of protection in Canada is the life of the author plus 50 years. The USMCA also requires the establishment of safe harbors for legitimate internet service providers, protecting them from liability for infringement by their users, provided that they comply with the notice and takedown requirements. Canada was granted an exception to this, allowing it to continue to use its notice and notice approach without internet service providers having to adopt the takedown requirement. Regarding trade secrets, the USMCA also provides strong protection for trade secrets, similar to US federal and state trade secret laws. The agreement requires that parties adopt laws to prevent the misappropriation of trade secrets, including by governments and state-owned enterprises, civil and criminal remedies against the theft of trade secrets, and judicial measures to prevent the disclosure of trade secrets during litigation. Canada has already amended its criminal code to enhance protection against the misappropriation of trade secrets. However, it remains a question whether Canada will be required to adopt legislation to provide for stronger civil remedies to protect trade secrets. In the enforcement area, the USMCA calls for significant measures to enhance border controls to stop IP infringement. It calls for strong measures to prevent the importation and in-transit shipment of counterfeit goods. It requires that customs officials be given the authority to inspect, detain, and destroy counterfeit goods. And it encourages collaborative border enforcement operations through the IPRC. The agreement also calls for enhanced remedies for IP infringement, including civil and criminal penalties, liability of direct infringers, as well as aiders, abettors, and governments. And it requires that enforcement procedures be available to prevent digital infringement of trademarks, copyright, and other related rights. There's likely more that Canada will have to do in terms of border enforcement, statutory damages for trademark infringement, and civil remedies for the misappropriation of trade secret. And so that's it on the IP side. Let me turn this over to Wendy to talk about the digital chapter and privacy. Wendy?
Hi, everyone. Well, the digital chapter is a brand new component of the trading relationship between the three countries. And it's really not surprising that NAFTA didn't deal with this because the agreement was negotiated even before dial-up internet. So definitely the world has changed a lot in the past couple of decades. And inclusion of the chapter was a really important negotiating objective for the US. And that's in recognition of the fact that digital trade is a huge contributor to that economy. Just think of giants such as Facebook, Amazon, Google, Netflix, and many others, which are all US based. And so the objective of the chapter is basically to ensure that there are as few barriers as possible to digital trade. But at the same time, the chapter acknowledges that in some cases, rules that restrict cross-border transfers of personal information, or like rules that restrict cross-border transfers of personal information, the barriers exist because of legitimate policy objectives to protect consumers. So as a result, the chapter also encourages the adoption by the parties of some baseline measures to protect privacy and data security, while still trying to ensure that these types of measures do not become barriers to the free flow of information that's necessary to conduct a lot of these services. So what are some of the key requirements that the chapter puts in place to ensure that digital trade can be maximized? First, it restricts the USMCA parties from imposing customs duties or similar types of charges on importation and exportation of digital products and services. And importantly, it also says that if internal taxes, fees, or charges will be imposed, that has to be done in a non-discriminatory way. And if you've been paying attention to the news, this has recently been a tense issue between France and the United States. The United States on July 11th imposed a 25% tariff on French luxury products, and that was in retaliation for France's imposition of a 3% digital services tax that the US says is discriminatory against the companies I mentioned, like Google, Facebook, and Apple. And the US is also investigating similar digital services tax that may be adopted by countries around the world. There's also a number of other important requirements in the chapter. The agreement seeks to ensure that data can be transferred freely across borders, which is really important to various types of service providers like cloud companies and software as a service providers. And those are also enormous industries in the United States. And for similar reasons, it restricts the ability of the parties to impose what are called data localization measures, and those are measures that require companies to store and process their data locally. There are still some notable exceptions to those restrictions. The parties and their procuring entities are still allowed to place restrictions on data transfers in the case of sensitive information, and these reservations should allow the Canadian federal government and the provinces to continue to impose some restrictions on cross-border transfers of personal information where that information is in the custody or control of the government entity. The chapter also seeks to facilitate digital transactions by permitting the use of electronic authentications and signatures, and it also protects against the forced disclosure of proprietary source code and algorithms. And that's something that'll be important to watch as all three countries, including Canada, develop new legal frameworks or regimes for artificial intelligence or AI, since those proposals include some consideration of rights of access to AI algorithms by consumers, which is similar to the GDPR. Also notable is the requirement for all three parties to adopt laws that limit civil liability for internet platform providers for third-party content, and that's to protect those providers from host liability. And it will be interesting to see how this develops in Canada, since these laws in Canada are mainly governed by common law, and there's no statutory regime that's similar to the US Communications Decency Act. So as I mentioned, in recognition that some restrictions on digital trade exist with a view to protecting consumers, the chapter does acknowledge that each country should offer enforceable consumer protections for privacy and data security. And the basic concept here is that if each of the countries has a satisfactory regime for protection of these rights, then in theory, consumer data should be freely tradable amongst the countries because it should be protected no matter where it's processed and stored. However, the requirements in the agreement right now are very basic, and the content and enforceability of such laws is left up to each country. So we can expect to still see wide variations. And it does remain to be seen whether inclusion of this chapter will have a harmonizing effect as the three countries further refine and develop their privacy and cybersecurity laws. So that brings our presentation to an end. Thanks for attending. And as always, we encourage you to access our other recordings and materials on GoXL.
Thank you, Wendy. It's a pleasure, and thank you for listening.